Legal implications. Nurses have to understand the legal framework of healthcare in order to be able to adequately protect the client's rights and the nurse from liability. Nursing is perceived as the most trusted profession. The only time in recent years that it was not perceived as the most trusted profession was at the 911 when firefighters achieved that status. Nurses follow legal guidelines from statutory laws, regulatory law, and common law. There's no need for us to fear the law if we understand it as it applies to the nursing profession. In fact, it can be very beneficial. Statutory law, or statutes, can be on the state level, and it's, for example, our Nurse Practice Act that describes and defines the legal boundaries or the scope of nursing practice for each level. As a nursing student, LPN or RN, you're required to be familiar with your state's Nurse Practice Act as it applies to your level of nursing. It also involves, at a state level, the regulatory or administrative law, where the administrative body makes decisions. An example is our State Board of Nursing that passes rules and regulations. And common law, which is the judicial or courtroom decisions. Statutory law is also on the federal level. For example, the Americans with Disabilities Act that protects the rights of the disabled throughout society. It can be either criminal or civil, and civil laws will protect the rights of individuals and provide for fair and equitable treatment, whereas the criminal laws protect society as a whole and provide punishment for crimes. Underneath criminal law, we have felonies, which are serious crimes that have a penalty of greater than 1 year imprisonment or death, and misdemeanor, which is a less serious crime with penalties of less than 1 year imprisonment and or fines. Standards of care are legal requirements for nursing practice that describe minimum acceptable nursing care. It reflects the knowledge and the skill that's ordinarily possessed by practicing nurses. The American Nurses Association has developed standards for nursing practice, and they constantly are reviewing these and updating them as necessary. And individual facilities will have additional standards of care that are usually based on the standards of a professional organization. They may also be known as policies and procedures, and it might be a textbook that's referenced for many of the policies and procedures. For example, I know that at Pratt Regional Medical Center that inserting a Foley catheter is referenced to the clinical skills textbook that is found on each nursing unit. Now, in a lawsuit, a nursing expert is going to testify as to whether the nurse or nurses in question adhered to the standards of care. In other words, would another reasonably prudent nurse in the same type, size, and location of facility with the same type of circumstances responded the same way? Different laws in healthcare include, once again, the Americans with Disabilities Act, which protects the rights of people with physical or mental disabilities, and it includes having appropriate access to areas such as widened doors, elevated toilets, handicapped parking, etc. The Emergency Medical Treatment and Active Labor Act, or EMTALA, is the anti-dumping law, and it states that a facility must stabilize a client prior to discharge or transfer, and transfer occurs if benefits of transfer outweigh the risks of transfer. A client can request a transfer in writing after being appropriately informed of the risks and benefits of transfer. The Mental Health Parity Act. If mental illness is covered by a policy, this law forbids health plans from placing lifetime or annual limits on mental health coverage. Clients can be held involuntarily if a court or healthcare provider determines that the client is a danger to him or herself or others. Advanced directives include living wills, healthcare proxies, and durable powers of attorney for healthcare. All nurses should be aware of the facility's protocol. Technically, if the client was of sound mind, documents should be honored. Healthcare facility must provide written information to clients concerning their rights, their right to refuse treatment, their right to complete advanced directives, etc. A living will is a written document that outlines the client's wishes in the event of a terminal illness or condition, and it can specify what procedures they do or do not want to be performed. A healthcare proxy or durable power of attorney for healthcare. This is a legal document that designates one or more people to make healthcare decisions if the client is unable to do so. And the decision should be made according to the client's wishes. For example, you don't necessarily have just one durable power of attorney. My father has myself and my siblings listed as his durable power of attorney in healthcare decisions. So any or all of us can make a decision regarding healthcare for my father. A DNR is a do not resuscitate. It specifies what the client wants done in the event of the heart stopping. It can be limiting. It may be a medication only with no chest compressions or defibrillation, etc. So they can be specific in their DNR. Uniform Anatomical Gift Act. Anyone over the age of 18 can make the decision to be an organ donor, but this decision must be made in writing for it to be legal. It is illegal for human organs to be sold or purchased. The Health Insurance Portability and Accountability Act, or HIPAA, is something that you should know inside and out. It protects individuals from losing health insurance when they change employment, but it provides standards that protects a client's privacy regarding personal information and healthcare records. Privacy is defined as the right to keep personal information from being disclosed. And confidentiality is protecting private personal information once it has been disclosed. Another law is restraints. We have the Federal Nursing Home Reform Act. Clients have the right to be free of unnecessary and inappropriate restraints, and standards have been set to reduce the use of restraints in the healthcare setting. In fact, in a lot of long-term care facilities, you will not even find restraints. Restraints can be used only to ensure the physical safety of the client and others, including the healthcare staff. Restraints can be used when less restrictive interventions have not been successful. And restraints can be used only with the written order of the healthcare provider. Licensure requirements will vary from state to state. It usually will consist of minimum education requirements from an approved school of nursing. All states require the National Council Licensure Examination, or NCLEX, for the RN and LPN examinations. So it doesn't matter what state you're in, you will take the same examination. And something else of interest, it does not matter if you have completed an associate's degree program or if you have completed a BSN program, you still take the same NCLEX test for the RN examination. Now, state boards of nursing do have the right to revoke or suspend licensure if a nurse's conduct violates the licensing statutes. Once again, I repeat, if you are the wild and crazy type person or a partying reputation, you may want to adjust your living style, or you may want to choose a different occupation because your conduct can reflect on whether you obtain a license or not. Additional laws that you need to be aware of will include the Good Samaritan laws. Good Samaritans will provide emergency assistance, and these laws will limit liability, and it offers legal immunity if you stop to help, as long as you act without gross negligence and within your level of expertise. Now, it's not necessarily going to prevent someone from suing you, but it will offer you some legal protection. If you commit to providing care, you cannot leave the client until the client's care is transferred to someone who is equally capable or more qualified than you are to provide that care. And if you do not properly transfer client care, you can be held liable. There is also failure to act laws within the Good Samaritan laws, whereas it is illegal in some states not to provide Good Samaritan care. Public health laws are laws that protect public health, that advocate for the rights of people, regulate health care and health care financing, and ensure professional accountability for the care that is provided. These are laws for communicable diseases and immunizations. We also have the Uniform Determination of Death Act, which is a basic definition of the point at which a client is considered legally dead. And it can be either cardiac death or brain death, and that is up to the individual provider. Nurses are required to treat a patient remains with dignity. Autopsies can be requested by the client or the client's family, or they might be required by law. The medical examiner will determine the necessity for an autopsy. Physician-assisted suicide. This is legal in the state of Oregon. It does violate the Code of Ethics for nurses. Mandated reporting. Certain people in certain professions are considered to be mandated reporters of instances of suspected abuse and neglect. Failure of a mandated reporter to report is a crime. Nurses and nursing students are mandated reporters. So let's look at some of the civil and common law issues. We'll start off by talking about torts. A tort is a civil wrong made against a person or property. An intentional tort is intentional, and it violates a person's rights. Assault, battery, and false imprisonment fall under this particular category. Assault is an act that places a client in fear of harmful or offensive conduct. Basically, there's no touching with assault. Battery is any intentional touching without consent, and it's considered to be harmful or offensive. So in other words, touch is involved. False imprisonment is unjustified restraint without legal warrant. The client must be aware of the confinement. If they're unconscious, though, the law does not apply. So restraints can be considered to be false imprisonment. Bedside rails can be considered to be false imprisonment. So we talked about intentional tort. Let's move on to quasi-intentional. This is the violation occurring, but the intent is lacking. It might be an invasion of privacy or the HIPAA laws. So you may see a release of a client's medical information to an unauthorized person. Facilities will usually have someone that is designated to handle the media. So a particular person, a nurse, is not required or authorized to talk to the media about a particular medical situation that has gone on. A particular person is designated and they are provided with the appropriate information. Defamation of character is a publication of false statements that damage a person's reputation. We have slander, which is the spoken word, and libel, which is the written word. And then we have the unintentional tort. We have negligence, which is conduct that falls below a standard of care. And malpractice, which is professional negligence, in which the care falls below the standard of care. We move on to informed consent. Informed consent is the agreement to allow something to happen, such as surgery or some type of an invasive procedure. The person who is to perform the procedure is the one who is legally responsible for obtaining the informed consent. In other words, the physician. This must be based on full disclosure of the risks of the procedure, the benefits of the procedure, alternative procedures, and consequences of refusing the procedure. Information must be provided in a language and in terms that the client will understand. If informed consent is not obtained, it can result in negligence. Informed consent must be witnessed. Now, phone consent is acceptable, but you should have 2 or more people witnessing the consent. Basically, what you do is it's like a durable power of attorney, for example, who is not at the hospital, but we are needing to obtain consent for this client to go to surgery. We've had an elderly client fall and break their hip. They are medicated and they cannot provide consent. They're confused. So you call the durable power of attorney. So-and-so has fallen and broken their hip. You're aware of this. The physician has come in and determined that they need surgical repair. This is the procedure. You read off the procedure that the physician wants to perform. Is this okay for us to do or not? The person says, yes, it's okay. So, okay, you've provided consent for this procedure. I need to have a second I need you to tell a second person that it is okay for this procedure to be performed. So you hand the phone to your coworker. The nurse will say, hello, I'm so-and-so. Are you consenting to such and such procedure being done on this person? And then you both sign the form and you write phone consent from the person and you write their name. The client to provide appropriate consent has to be competent. They have to be a legal age. They cannot be under the influence of mind-altering substances such as narcotics. Or it can be a legal guardian or power of attorney. And the client cannot be declared legally incompetent. And you can review these in box 23.3 in your textbook. If the client is if you are unable to obtain informed consent, consent is implied if a procedure is life-saving in an emergency situation. You have someone come in from a motor vehicle accident, they're unconscious, they're unable to provide consent. Consent is implied if it is a life-saving measure. Continuing on with abortion. Abortion is legal in most states in the first trimester. Viability tests may be required if the fetus is over 28 weeks gestation. And parental consent or court decision may be required if it's a minor. Nursing students, you are liable if your actions cause client harm. That liability may extend to your instructor, it may extend to the facility, and it may extend to the college. You as a nursing student should not be assigned a task that you are not qualified to perform, or you should not perform a task without appropriate supervision. In other words, if you have not been checked off on a task, or if it is a task that is invasive, then it is not a task you should be performing without your instructor or another qualified nurse who has agreed to supervise watching you. You should not, as an employee, perform any skills that you perform at your place of employment until those skills have been learned and or authorized by your instructor. On the flip side, you cannot perform any of the skills that you have learned at school at your job site. It's illegal. And you cannot take verbal physician orders. So what about malpractice insurance? Well, it's not required, but it does provide for a defense in a professional negligence or medical malpractice suit. A lot of facilities will cover the employees that are working underneath them, but a nurse can also be held liable for just giving neighborly advice, and institutional insurance will not cover that. So if your friend or your neighbor is asking you for advice and ultimately they follow that advice and it proves to cause harm, then you can be held legally liable. So you need to be very careful about any advice that you give. Abandonment and assignment issues. When we have short staffing on a unit where there's not enough staff to provide competent care or involves too much overtime, a nurse can make written protests to the administration. Anything that you write down, you should maintain a personal copy when it involves a situation like this. But understand that this protest does not alleviate your responsibility if patient harm occurs because of short staffing. Walking out on a scheduled shift due to short staffing may result in you being charged with patient abandonment. Floating. Working is defined as working in a different unit than the one that you're normally assigned to due to patient census or acuity. The nurse must inform a supervisor of a lack of experience in an area that you might be floated to. So if you're a medical surgical nurse and you're floated to the intensive care unit, well, you need to let them know that you've never worked there before, that you're not familiar with the area, that you're not familiar with the skills. Hopefully some type of orientation will be provided, but you should not be asked to provide any patient care that is going to be beyond what you're capable of doing and what you're comfortable doing. A nurse should ask for and receive orientation to any unit that they have been floated to. Healthcare provider orders. If a nurse finds an order that a doctor has provided to be erroneous or harmful, you can request clarification. You should follow the chain of command if, after clarification, the order remains erroneous or harmful. You, as the nurse, are legally liable if an inaccurate or inappropriate order is performed and it causes harm. Always document notification of the healthcare provider and any response received. Verify all verbal and telephone orders by repeating that order, and always be familiar with the facility's policies and procedures. And risk management. This is a system of ensuring that appropriate nursing care through the identification of potential hazards and elimination of those hazards before harm occurs is done. It's accomplished through looking at possible risks, analyzation of those risks, acting to reduce those risks, and evaluation of the steps that are taken to reduce the risks. An occurrence report or an incident report or a variance report, they're all the same thing, is a tool that's used to report or identify deviations from standards of care and helps determine what is necessary to correct any problems. It is used to help prevent future occurrences of the same thing happening. It is not a part of the client medical record. Do not document completion of an occurrence report in the client's medical record. This is a red flag to an attorney in the event of a legal case saying, hey, look, something wrong happened or something inappropriate happened. It does demand that you provide complete documentation. Remember, if you did not document it, you didn't do it. A nurse's notes are always reviewed in medical lawsuits. Medical lawsuits often don't occur for years following an incident, and your documentation is all that you have to rely on to remember the care that you provided in a certain situation. So your documentation needs to be complete. Consider membership in a professional organization if you're interested in changing any of these laws, rules, regulations, or policies that don't accurately reflect nursing practice.